We are recording.
Okay, thank you. Good afternoon, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting with Judge Mall and Judge Baer on the matter of State of Connecticut versus LANIER. This argument is being conducted over the Teams platform, so everyone is appearing by video conference. In addition, the argument is being streamed live over the branch's YouTube channel. I would remind counsel that to the extent there's any protected information involved in this case, you should be careful not to disclose any of that during the argument. I'm going to ask everybody to introduce themselves so that we can make sure we can hear and see each other okay. I'll start with the judges, then counsel for the appellant, and counsel for the appellee. Again, I'm Judge Bright.
I'm Judge Mall.
Judge Baer.
Pam Nagy, Assistant Public Defender.
Melissa Strito, Senior Assistant State's Attorney.
I can hear and see everyone okay. I assume that's true for everyone else. If at any time, excuse me, if at any time you are unable to hear anyone, please say so. If you're unable to see anyone, please say so. And if you get disconnected from the video conference for whatever reason, please click on the link and rejoin. We will suspend the argument until we know that we have everyone present. I would remind counsel that although we are all appearing virtually, this is a court proceeding, and I would ask counsel to conduct themselves the same way they would if they were standing in the appellate court here in Hartford. I'm going to ask everyone to keep their microphones muted when they're not speaking to avoid any background noise and any possibility of people talking over each other. The judges will do the same thing. If we have questions, we're going to raise our hands and ask that you recognize us. And if you don't, then we'll just jump in like we would in the courtroom. But again, we want to try talking over each other during in this format. And I apologize for my phone beeping for some reason. And I would ask, though, that you keep your cameras on at all time so that we know that you're present and engaged in the argument. Each side will have 20 minutes to argue. I will keep the time. We do not have our light system, so I have signs that I will hold up at 2 minutes and at 1 minute, and then when time is up. The appellant can reserve time for rebuttal. And with that, I think we're ready to go. Attorney Nagy, are you ready to proceed?
Yes, I am. Thank you. May it please the court. My name again is Pam Nagy, Assistant Public Defender on behalf of Travis LANIER. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
Sure. Okay, go ahead.
Thank you. The defendant has raised 3 issues on appeal, and I'd very quickly like to jump to the 3rd issue, which is the issue about the court sentencing Mr. LANIER as a persistent, serious, or a persistent felony offender. In January of 2021, the Supreme Court decided State versus Biscoff, which pertained to whether or not Public Act 15-2 was retroactive, and 15-2 was dealt with possession of narcotics. Certain quantities were downgraded from felonies to misdemeanors. And the issue here pertained to whether or not 15-2 was also retroactive to Mr. LANIER's convictions. Because the Supreme Court affirmed the appellate court decision, which is what the trial judge followed in this case, and this court is bound by the Supreme Court, so therefore our claim is no longer viable, and I would withdraw or ask that that issue be withdrawn. Turning to the first issue, the trial court violated Mr. LANIER's constitutional rights, and particularly his right to present a defense, his right to confrontation, by preventing him from questioning the complainant, who was the state's key witness, on matters pertaining to his motive and his bias. And in particular, defense counsel wanted to show that the complainant here was vulnerable to having his probation revoked, and that this is what was a possible motive for him to fabricate the claims in this case. And in particular, what had happened in October of 2017, he had started a period of probation. There were 2 new arrests during this time period, and just 3 weeks prior to this incident, he had pled guilty to violating the probation. He managed to not get any jail time as a result, and he was reinstated to probation. And the defense theory here was that that the complainant fabricated these claims to avoid being arrested for larceny, because the claim here by the defense was that the complainant had actually stolen Mr. Moniz's watch. And so defendant wanted to expose that he had a potential motivation here to avoid being arrested for larceny, which could then potentially have his probation revoked, and at this point could have faced jail time. Yes.
So if this were a case where the police showed up to break up an argument, I would understand the argument more in terms of the probative value versus the prejudicial effect. But in this case, where it was the complaining witness who twice called 911, does that make the probative value less? Because if somebody wanted to avoid police involvement because they committed a larceny, why would they be the ones that initiate police contact?
Well, at this point, the complainant already knows that now they've accused him of stealing a watch. So we don't know at what point he could have decided, assuming, this is what happened, we don't know at what point he could have decided, like, oh, I've got to do something about this. So if he's making himself out to look, to be a victim, well, then it makes sense that he would do this. The bottom line here, though, is that the jury was entitled to understand his status here and that he was vulnerable. And it could have impacted how he portrayed what happened that night. And defendant has a right to question somebody about matters pertaining to motive and bias. So the fact that he called 911 or attempted to call 911, well, that's something for the jury to consider as to whether or not they believed he was really a victim or whether or not he was actually just fabricating these claims. But to prevent defendant from even presenting facts about his probationary status was a violation of his rights. And what the court here held was it was more prejudicial than probative, as well as it was speculative that he would have his probation violated. Neither of those rulings make any sense. First of all, the issue wasn't whether or not he would have his probation revoked. The issue here was his state of mind, and that's what defense counsel wanted to show. It was important what he thought. If he's arrested, that's a condition of probation. Could he have his probation violated? If the police showed up and they, maybe he wasn't arrested for larceny, but they determined he was extremely inebriated after being on probation for a DUI. That could also be a condition of probation that, it could have revoked his probation or changed the conditions. But the jury did not get to hear any of that. And as well as it being more prejudicial than probative, that really doesn't make any sense. It doesn't make any sense. Is it prejudicial to the state? Is it prejudicial to the complainant when we're talking about the defendant's right to present such evidence? It doesn't make sense. And, what's important here is what the state is claiming is that defense counsel wanted to talk about the facts underlying the arrest here, that he wanted to get into the disorderly conduct and the arrest for violation of a protective order. And that is not the case. That is not what defense counsel wanted to do. Defense counsel wanted just to get into the fact that there were arrests and how that affected the probation. So the state's reference to State versus Rivera, the Supreme Court case, where in that case, the defense counsel did want to question about the underlying facts pertaining to the arrest in those cases, that case is distinguishable. That's not what defendant wanted to do here. And I will point out, as far as the harm, The state's claims, well, he had ample opportunity to cross-examine the complainant and to bring out inconsistencies in the complainant's testimony. While that's true, when you talk about matters pertaining to motive and bias, even when there is ample cross-examination, if you are prevented from bringing out any facts pertaining to motive and bias, then it is not harmless. And that's State versus Baltus, State versus Colton. There's quite a few cases that talk about that. And that's what we have in this situation. The state's case here was not strong. Clearly it wasn't strong. The jury acquitted him of 5 out of the 6 charges. So they clearly had some problems with the complainant's testimony. You have a defense that is presented. You have the so-called accomplice, Mr. Moniz, who gets up and testifies that this was all him. Defendant had nothing to do with this. And in fact, that's the first thing that the defendant told the police that very night. He said, this is between Mr. Moniz and the complainant. It was something, that was between them, and Mr. Moniz actually indicated he's the one that hit the complainant, and it was the defendant who tried to break things up. There was also, many inconsistencies were brought out about his story, but 2 of the, I think the strangest things that really shows that it could be just a far-fetched tale here. He's claiming there was this big robbery and burglary, and they go into his house and his apartment. Defendant takes this envelope of the rent money with $800, and yet only takes $300 of it. And then after this, vicious attack and robbery, where defendant threatens to shoot him if he goes out on the street and says anything, they invite him over for drinks. And the complainant testifies to this. So there were problems with his story. The jury clearly believed it, and the state's attorney at closing argument capitalized on this. Knowing that defense counsel could not present this evidence, the state's attorney argued several times, where is the motive? Defense counsel hasn't presented any motive for the complainant here to fabricate. Certainly added to the prejudice here. Overall, and one more thing, the complainant also admitted that he needed money. He was going through a divorce. There was evidence here which could have also shown that, there was a reason for him to have perhaps stolen the watch in the first place. For all of these reasons, if the jury had known that there was a motive here, or there could have been a motive for him to fabricate, they could have just believed that they all went to the apartment together. It was a peaceful thing. The complainant offered to give them money, and there was no burglary at all. So for those reasons, it's harmful error. With regard to the second issue, the burglary instruction, I did send up a letter of supplemental authorities yesterday, citing to State versus Brown and State versus Ruaco. And that's simply for the proposition here. The state claims that this claim of instructional error was waived, and those cases stand for the proposition that it is the state's burden to show that there is a waiver under Kitchens. And in this case, what the state, on page 35 of its brief, cites to the charge conference where there was a discussion about the burglary charge, and cites the state, or I'm sorry, the court, when it starts to talk about the different crimes, and when it mentions threatening, it says threatening is defined as, and then the court literally says, et cetera, et cetera, et cetera. And what the state says in its brief on page 35 was what the court was talking about at that point was the definition of threatening, and cites to its appendix, page 78, and puts in the court's charge, the actual charge that it gave to the jurors on burglary. What the state does not provide is the court's proposed charge. We don't have the draft. The draft was never made an exhibit. It's not an ID exhibit. It's not a court exhibit. So while the court did give the parties a draft on the first day of evidence, which was May 15th, the charge conference took place on May 20th, There's not enough evidence here to conclude. We don't know what was in that draft. We don't know if the court simply had the statutory language, or if it was just blank, or if it said, I'm going to insert something here. We don't know. All we have is et cetera, et cetera, et cetera, and then we have the final charge. So this claim is not waived. If, however, this court concludes it is waived under State versus McLean, this court can review the claim for plain error. And here, whether you're looking at plain error or if you're looking at under Evans-Golding, the bottom line here, and the state, notably, the state doesn't say there's not a mistake here. Doesn't say that the charge was not incorrect. What the state says, it gets into whether or not it was harmful or plain error. There's no question here. The court did not define the elements of threatening. It simply read the statutory language. So it did not indicate to the jurors there had to be what a physical threat meant. A physical threat is more than mere words. A physical threat means there has to be some action or some sort of gesture indicating that the person has the immediate ability to carry out that threat. And it's the victim's perception that's essential. And that's also part of the instruction. Didn't define that it has to put the victim has to believe that it's imminent and that there's a substantial fear or a fear of substantial physical injury. So for all of these things, the jury was not instructed as to what those actual elements were. The state claims it's harmless because there was enough evidence, for instance, for the jury to find that a larceny was intended, and which was one of the other crimes that the state alleged was the underlying crime for the burglary. And the state cites to State versus Wohler in its brief. State versus Wohler is talking about cases when the claim is a sufficiency of the evidence claim. And so what those cases say is that when the state charges a defendant with committing a crime in two different ways, such as from different subsections of a statute, and if there's a claim of insufficient evidence, if the court gives a charge, with indicating both ways to commit, and there's a claim on appeal, well, there wasn't sufficient evidence for this to commit it this way. The law and what Wohler stands for is that as long as there's sufficient evidence for the other crime, then it's, we presume the jury found under the correct charge and not the one where there wasn't enough evidence. That only pertains to sufficiency of the evidence claims. I cited to State versus Montanez, where it's an instructional error and you have a general verdict like you do here. You don't know if the jury found he intended to commit threatening, or we don't know if they found he intended to commit larceny, and there were two other crimes, but they acquitted him of those crimes. So I think it's highly unlikely they found he intended to commit robbery, etc. But the bottom line here is that because we have a general verdict, because they didn't have to be unanimous on the underlying crime, we don't know if he was convicted of intending to commit threatening when they don't know exactly what the elements are. And under Montanez, the defendant is entitled to a reversal of that conviction. And very quickly, what happened in Montanez, there was an assault charge and the defendant was charged as both a principal or an accessory. And the problem was with regard to accessorial liability, there was a claim of self-defense. The Supreme Court held when you're an accessory, you have to look at from the perspective of self-defense, it has to be from the perspective of the principal. And so in that case, because the court did not give that instruction, it was unknown if the defendant was convicted of assault as either a principal or an accessory. And for that reason, the conviction had to be reversed because of the faulty charge with regard to accessorial liability. And that's what we have in this case. If there are no questions, I will reserve my remaining time for rebuttal.
I see no questions, so you'll have 3 minutes and 45 seconds for rebuttal.
Thank you.
Attorney Strito.
Thank you, Your Honor. Good afternoon. My name is Melissa Strito. I am a Senior Assistant State's Attorney on behalf of the state of Connecticut. Your Honors, the trial court in this case reasonably ruled in its discretion that inquiry into conduct by the victim that potentially might have led to a probation violation was too speculative and involved too many unknowns, and that such inquiries were therefore more prejudicial than probative. I heard the defendant say that prejudicial versus probative doesn't make sense because who is it prejudicial to? Well, the prejudicial versus probative inquiry is always something that a trial court has to do when deciding whether to admit evidence or allowing an inquiry. And it does make sense because even relevant evidence may be excluded in the discretion of a judge if it has the tendency to confuse the jury. And in this case, that's exactly what happened. The trial court said this is all too speculative. It involves too many hypothetical possibilities, too many coulds, ifs, mights, and possiblies. And there's too many leaps that would be involved in order to make it relevant to the victim's motive to fabricate. Yes, Your Honor.
Can the court apply the probative versus prejudicial analysis when we're dealing with a constitutional confrontation claim?
I think it has to. That's the first step in any inquiry, including constitutional claims, is did this violate the rules of evidence? First, if it didn't, then it doesn't violate the Constitution. But when the trial court is being asked to admit certain evidence, it has to follow this sort of flow chart, if you will, and that is one of the steps in the analysis, because the trial court has the duty to preclude evidence that would take the jury from the realm of reasonable inference to the land of impermissible speculation, whether it be constitutional or evidentiary. That's so.
So let me just ask you, in your brief, you say that the trial court determined that the evidence wasn't relevant. And I didn't see that in the record where the trial court said the evidence wasn't relevant. It seemed that the court just went immediately to the residual exception and balanced, well, not even the residual exception, just balanced prejudice versus probative. Is that correct?
It is ultimately correct. There were a couple discussions about these matters on the record, and in the first discussion, there was a discussion as to whether arrests for new crimes while you're on probation would be relevant to the victim's veracity. So the court did say that an arrest for violation of a protective order and disorderly conduct was not relevant to his veracity. So that was during one discussion. But then when this issue came up again, the court ultimately did rule that it's just too prejudicial to be probative, more prejudicial than probative, rather. So
the balance of prejudicial versus probative is usually done in the context of kind of the catch-all exception to the hearsay rule. So if something is otherwise not admissible, the court can admit it if it's more probative than prejudicial. And this is kind of my concern here. If the court hasn't said that the evidence being offered is irrelevant and it relates to a confrontation of a witness, are there cases which have said it's okay for the court to exclude relevant information in that circumstance because it's more prejudicial than probative?
Yes, some of the cases that I cited in my brief stated that a court can exclude even relevant evidence if it finds that the prejudicial effect outweighs any probative value. And the other, going to the constitutional part of it that I know that Your Honor is concerned with, part of the inquiry for that piece of it is whether the defendant was allowed to explore the victim's credibility and motive to lie in other ways, in ways that weren't too speculative. And the state asserts that he was allowed to do that for many of the reasons that counsel mentioned. He was allowed to ask the victim about the watch, whether he had been involved in the theft of the watch. Why did he tell the 911 operators about the watch if, as he told the jury, he didn't know anything about the watch? If the defendant's plan had been to rob him, why did he take only $300 or $400 out of an envelope that contained $800? Why did the defendant invite you back to his apartment for a drink afterwards, after he had assaulted you and robbed you? Why did you later tell the ER personnel that you thought the defendant drugged your drink, but you never bothered to mention that to the police when they spoke to you? How did you know that the defendant went north or south on Main Street after he left your apartment when your apartment doesn't even have a view of Main Street? And the defendant was also allowed to explore the defendant's credibility in general in other ways by asking whether he had, he was on probation. He was on probation at the time of the crime for a felony DUI, whether he had lied to the police in the past on an unrelated incident. So certainly the defendant was allowed to explore these areas and also argued to the jury in closing argument that the victim made these allegations against the defendant up because he was worried that he was going to get violated on probation, revolving around this allegation of a watch theft. And so he was afraid he was going to go back to jail. So he made up the story to, quote, get ahead of it. So certainly the defendant was able to get his defense theory before the jury, both on cross-examination and closing. And then he put on his own witness to say what his story, his version of events was. And the defendant said, look, the victim's testimony is more consistent with the defendant's cohort story, that this was all, this was all an agreement. We're going to go to the victim's apartment to get money that the victim owes me for stealing my watch. And that's why he only took $300 instead of the full $800. That was the agreed upon price. That's why I invited him to come back to my apartment after, because, everything was good after that. So, to the constitutional question, I think that the defendant was able to fairly explore those issues. And so to the extent that the trial court limited any inquiry, it was just limited to areas that were simply too speculative and had too many layers of conjecture. And the trial court did properly exclude those pieces of inquiry. With respect to the second issue of the instructional claim, I have to disagree with counsel that the cases that she cited in her supplemental authorities letter stand for the proposition that is claimed. I read those cases, and it does not say that the state bears the burden of proving waiver. What it says is that the record must be adequate to review a claim of waiver. And in the two cases cited, now going more towards what she said, that the record was inadequate for review in those cases. And of course, Kitchens and its progeny instruct that waiver cannot be found on an inadequate record or a silent record. So, but I disagree that we have a silent record here. The proposed written instructions were given to defense counsel, of which there were 2, for review 5 days prior to the charging conference. My understanding from what the record shows is that there was no change between the proposed instructions on that issue and the final instructions. I will agree that there is no marked up proposed instruction copy. I don't think that was marked for the record, but some of the cases, I think Bellamy is one, says that it doesn't have to be marked. It's whether the record shows in the totality of the circumstances that there was a waiver. That particular instruction was discussed at length on the record, and the defendant never raised any claim that they were incomplete. The court gave ample opportunity both for the 5 days leading up to that, and then even overnight the next day, to raise an issue. And perhaps most importantly, to what the defendant is claiming now about the inadequate record, after the defendant gave the charge. After the court gave the charge to the jury, where certainly that language was omitted, the defendant did not make any exceptions. So I would disagree that the record is inadequate to show a waiver. I think that it is more than sufficient, especially when compared to some other cases where the record is a lot more thin. With respect to the merits, there is no possibility that the jury was misled in the context of how the case was litigated, because the state did charge 4 alternate ways in which the defendant could have committed burglary. Now, admittedly, I agree with counsel that the cases I cited are sufficiency of the evidence cases, and that's simply because they're instructive in this regard. There was no case directly on point to cite to with respect to an instructional error. But the way that the case was tried is important. The evidence as presented showed that the threatening really happened before the parties went to the victim's apartment. He was physically assaulted. Yes, Your Honor.
Wasn't one of the allegations of threatening that after taking the money, they said, the defendant said, if you come outside, I'll shoot you?
That was a piece of evidence that did come out, and my argument is that at that point the burglary had already been completed. The defendant unlawfully entered the victim's apartment, took the money. The larceny was complete at that point. He said, I'll shoot you, but it wasn't, his intent was not, the intent to commit larceny was already complete at that point. The larceny was already complete at that point. The burglary was already complete at that point. So you don't even need any subsequent threatening. So that's why I'm saying the context of how the evidence came out.
You're talking about the state's theory of the case, not what your view is. My question is, at trial, did the state argue that the threat to shoot the complainant if he went outside could be sufficient to a sufficient threat to convict of burglary?
I believe the state did argue that, yes.
Okay, so if you're going to tell us you got to look at the theory of the case, don't we then have to look at the theory of the case?
But what I'm saying is that you have to go back to the standard of review for instructional error, which was whether the jury was misled. And
right, but the defendant argues that if we don't know, in this case, whether the jury relied on an inaccurate charge for threatening or an accurate charge for larceny, because it's a general verdict, the benefit of the doubt goes to the defendant. Do you agree with that?
I think as a general proposition, that's correct.
Okay, so then how do you get around, you don't seem to argue in your brief that you don't argue that the threatening charge was sufficient. You ignore that. So assuming that the threatening charge was insufficient and assuming there was no waiver, how do we know here that the jury did not rely on the insufficient threatening charge as opposed to the sufficient larceny charge?
Again, I think it's because of the way, irrespective of what the state said in closing argument, I think it's the way that the case was tried. For threatening, you're talking about a physical threat, and I think that the evidence showed that the physical threats came before they arrived at the victim's apartment, when he was being assaulted and literally physically shoved down the street, and told, if you don't, while they're shoving him, if you don't comply with us and get the money, we're going to hurt you. At that point,
wouldn't that threat assume that's the threat for a moment. Wouldn't that threat continue up to the doorway when they make the complainant go into his house?
Right, but that's my point. Once the defendant is in the apartment, the way the case was tried, it is very clear that it was his intent to take that money. I mean, he said that, that was his intent from the jump, was to get that money. So I don't think any reasonable observer would have found threatening as the basis of the burglary, when it was very clear, the way the state tried the case, that his intent was to go get that money.
So your argument is the burglary wasn't done for the purpose of threatening. Threatening was done to set up or accomplish the burglary.
Yes, I believe that is the way that the case was tried. I don't want to mislead the court, because I do believe that the state did argue in closing about the threats that the defendant made afterwards, but I don't recall off the top of my head whether the state was just recounting the evidence or whether the state was saying that those threats also constituted part of the burglary. But I don't believe there is any question that the state's theory from how it tried the case was that the defendant's aim all along, his intention, was to steal this money. And so...
But that just raises the question for me of why even include threatening as one of the 4 ways of committing the burglary. If it wasn't the purpose of the burglary, why include the threatening? Why not just rely on the larceny and the robberies? So the fact that the threatening was included must have been somewhat important to the state's theory of the case.
I suppose that's true. It doesn't seem to me that is how the evidence ended out coming out, though.
Okay, thank you. That keep going. That answered my question.
I'm sorry. I thought my time was up. With respect to your question before about that I ignored whether your words, I ignored whether the instruction on threatening was correct or not. I mean, the court, thank you, Your Honor, the court set forth the statutory elements of threatening. What it didn't do, as I did note in my brief, is give the further explication of those elements that are found in the model jury instructions. So I don't know. No, I didn't make an argument that was an error, but to answer your question, I don't know whether it is. I don't know of any authority that states that failure to follow the model jury instructions is error. And in fact, the jury instructions, if I'm remembering correctly, say that these are just meant to be a guide, and we don't even hold them out as being legally correct. So that's my response with respect to that. I will be more than happy to answer any questions the court has for me at this point on either one of those issues. And if there are none, then we ask the court to affirm the judgment below. Thank you kindly, Your Honors.
All right, I don't see any questions. So Attorney Nagy, you'll have 3 minutes and 45 seconds.
Thank you. I'll take the instruction first very quickly with regard to Ruaco and Brown. Obviously, Your Honors will read the case, but I'm just pointing to page 742 of Ruaco, where the court says, if we adopted the state's reasoning and concluded that the record is inadequate, and as a result, the defendant's claim fails, that would place the burden on the defendant to provide a record sufficient to support the state's waiver argument. If the state intends to argue that the defendant waived a mandatory instruction, it was a different instruction in that case, obviously, the burden is on the state to secure an adequate record to support that argument. And then Brown also went on to say there was no draft of the proposed charge. And also in Brown, there was no record of the charging conference, which we do have that here. But that's where I get what I said. Those cases support the state bears the burden of proving an adequate record. It would make no sense for us to have to show that the record, that somehow supports or contradicts the state's waiver claim. It's their duty to make that, to show that. As far as the cross-examination, and particularly the state says that in closing argument, defense counsel was able to bring up that he might have, fabricated this because he needed, he was afraid that he would lose his probation. Well, those are just arguments of counsel. They're instructed by the judge. Those are simply arguments of counsel. And without any evidence to actually support that, because the judge did not let that evidence come in, it's just a baseless argument. It has no teeth. So that argument really has no merit by the state. What Your Honor is right, Judge Bright, the court never found the evidence was irrelevant. The court simply said it was speculative and also that it was more prejudicial than probative. Finally, what the state is claiming as far as the cross-examination that defendant was able to conduct, as far as the inconsistencies, those were simply matters trying to impeach him as far as his general credibility. None of that brought out anything about a motive or bias, and the jury would have no way of knowing that 3 weeks before he was in danger of going back to jail, but he was able to, plead to a violation of probation and escape jail time. And, 3 weeks later, had he been accused of a larceny, that might have been a different story. So for those reasons, if there are no further questions, we would ask that the burglary conviction be reversed. Thank you.
I see no further questions for the panel. I want to thank you both for participating in the virtual argument today. We look forward to seeing you both back in our courtroom here sometime in the very near future. We appreciate the briefs and the arguments. We will take the matter under advisement, and we will stand in recess until 3 o'clock. Have a good day.
Thank you.
Bye.